Hello again, friends. Welcome once again to the Supreme Court Historian YouTube channel. This is your chronicler returning after a long hiatus, much unplanned, and I apologize for that. But here we are. Let's move on and let's go back in time to 21st December 1950. Pannalal Jankidas versus Mohanlal, the first of our contract law cases. A very fascinating judgment where quite a few intricacies of contract law were discussed, the most important being remoteness of damages. That is why I have given that as the main heading of this particular video and not just the parties in the suit. Pannalal Jankidas versus Mohanlal goes back in time in our chronology as well. I have already covered Champakam Rajan, which was a 1951 judgment, of course, and I have already explained why I had to skip this and the next contract law case because I simply did not have the bandwidth to research these. Whereas Champakam Rajan, I hope, is a decent enough explanation despite the lack of research time given for those videos. So before much ado, let's just continue and look at the facts of Pannalal Jankidas versus Mohanlal. The case stems from one very historic moment in the chronology of Bombay's harbour especially, and I am going to look at a couple of videos. I'm going to point you to a couple of videos that deal with the impact of that particular historical event. It all started, as far as we are concerned, in February 1944 when a family firm of textile merchants represented by one of their family members, Mohanlal, procured the services of an agency firm, Pannalal Jankidas. The purpose was to buy bales of yarn. This is not cloth, this is the proto cloth, you might say, yarn which is used to weave into cloth. So Mohanlal asked Pannalal Jankidas to purchase several hundred bales of yarn and store them until further instructions were given, instructions for the dispatch of this yarn. Remember, the year is 1944. We are at the peak of the Second World War. As far as Asia is concerned, Japan is still going strong, and so there were a lot of instructions about what was to be done regarding goods that otherwise could be used as supplies for the army, whether the Allied army or the Axis army. So cloth had to be stored until permits could be procured for its dispatch outside the Bombay harbour. So out of 278 bales purchased by Pannalal Jankidas on behalf of Mohanlal, 186 had been dispatched. The remaining 92 were stored by Pannalal in his godown on Baroda Street, Argyle Road, Bombay. There's a reason why I have mentioned the address, because it is going to be very crucial. This is Baroda Street today. I'm looking at Apple Maps, and Baroda Street is, this is Masjid Bandar station to its west and Victoria Docks to its east. Further from Victoria Docks is this Cross Island, a landmark if you have visited Mumbai several times. Victoria Docks is not in much use today. Mostly it is used by the cruise terminal for the Angria cruise. Definitely something that you should visit. Anyway, that's the location of Baroda Street, not far from the harbour at all. A very convenient location as far as this agent was concerned, so that he could dispatch those goods whenever he received those instructions from Mohanlal. So agency is obviously something that will be discussed in the course of this particular judgment. I should warn you that. But the most important thing, which is not at all legal or related to legal aspects of this, happened within a couple of months of this transaction. April 14th, 1944, the Great Bombay Explosion. There are quite a few videos about this explosion, and I'm going to play one of them for just a few moments. So this is by 19th century videos back to life. They have even colorized this. The explosion happened on a ship that was docked in Victoria Harbour, in Victoria Docks rather, and that is some footage of the explosion. It was a double explosion. The ship Fort Steichen, it was called, was used to was used by the British for transporting gold as well as cotton, as well as oil, as well as explosives, everything that they could lay their hands on. It was wartime, and it was terrible tragedy, as you can see. If you look at the Wikipedia entry of the 1944 Bombay explosion, they inform us that over 800 people perished because of that, and several thousand more were injured. And obviously the loss to property was even more incalculable. There's a very good book on this, The Great Bombay Explosion, which I found in a library once upon a time. I don't know if this book is available anymore. Ennis, by John Ennis. But there is also a very informative video by somebody known as Nutshell. It's a very fascinating YouTube channel, The Nutshell. The Nutshell folks have described this in very much detail. This is Fort Steichen and all of that. So I'm going to link, I'm going to save links of both these videos that I discussed in the description of this video. The point is, the Bombay explosion, April 14th, 1944, happened somewhere over here. The ship was docked somewhere over here, and a vast area was devastated because of it, all the way to Bhaikara. And in fact, there are reports in that John Ennis book, for example, that the tremors caused by this were registered as far away as Shimla, which is more than 1700 kilometers away from that spot. So such a massive explosion during wartime was actually suppressed by the British controlled media. The first time the world heard about such a thing was on Saigon radio, which was controlled by the Japanese. Saigon, of course, is today known as Ho Chi Minh City in Vietnam. That at that time it was Saigon in Indochina. So a lot of secrecy around it, but nobody could hide all the damage that had been caused by it. Some of that damage included those 92 rather bales of yarn that had been stored in that godown on Baroda Street, Argyle Road, by Pannalal Jankidas for Mohanlal. So Pannalal Jankidas, acting as Mohanlal's agent, had purchased those goods and had stored them and would be paid for them after they had been dispatched. But before they could be dispatched, they had been destroyed by that fire. So Pannalal Jankidas had purchased those goods, was out of money, was out of goods, and therefore he asked Mohanlal to pay for those goods. Mohanlal refused, saying that he had asked Pannalal Jankidas to insure those goods against fire. Pannalal Jankidas claimed that this destruction was not by fire, was by an act of God almost, an explosion that nobody could have accounted for. Mohanlal refused to pay. Pannalal sued him. The trial court found in favor of Pannalal. Then Mohanlal appealed. Then that was overturned. Then Pannalal appealed to what was then the Federal Court of India, and post the Constitution became the Supreme Court of India. So it was in 1950 that this 1944 case finally arrived at the Supreme Court. And one of the most important things that was noted as part of this discussion on this particular case was what was known as the Bombay Explosion Compensation Ordinance 1944, passed by the Governor General, I beg your pardon, passed by the Governor of Bombay on the 13th of July 1944. This ordinance was to ensure that all the insurance companies who would have to pay out of their pocket for all the damages caused by that explosion, they would in turn then have sued the government of India and the government of Bombay for negligence. It was, when you view those two videos, especially the second video made by Nutshell, you will see that it was pure negligence on the part of Fort Steichen and the harbor authorities that had resulted in so much loss of life. And that is why the government was expecting a lot of litigation from the insurance companies. And to prevent that, the government came up with this ordinance saying that they would pay for all the insured goods that were damaged because of this explosion. You only had to apply for it, show the proof of insurance, show the proof of the inventory, and you would be compensated. So instead of the insurance company paying for the goods that were damaged, the government would pay for them. That would indemnify all those insurance companies. Unfortunately, Pannalal Jankidas had not insured the goods that Mohanlal had specifically instructed him to insure. And in fact, Mohanlal, it turned out in the facts of the case, had even been sending premium for insuring the goods against fire. Pannalal's case was that fire insurance would anyway not have covered these damages. So that was taken over by the Supreme Court. This discussion eventually resulted in the Supreme Court having to refer to one of our favorite contract law cases. By our, I mean all of us in the common law jurisdiction, be it the United Kingdom, be it India, Australia, Canada, United States, New Zealand, just about any English speaking country. And that case is Hadley versus Baxendale, which talks about remoteness of damages. And that is why we will be looking at that case, well, maybe referring to that case, but looking at the facts of this case in detail in the next video. I hope you will join me then, and I hope it will happen very soon as well. Until then, take care of yourselves. Have a good time. See you soon. Bye bye.